You're being compared by some people to George Wallace, who stood up against the federal government on integration. Is George Wallace an inspiration to you now in the struggle you're going through?
No, it has nothing to do about anything about race or color of one's skin. We don't discriminate in Alabama. This is about marriage, and we don't discriminate there either. All persons have the right to marry a person of the opposite sex according to the Constitution of Alabama's Sanctity of Marriage Amendment. And that's just the way it is, passed by the people of Alabama, some 81%.
Mr. Chief Justice, I'm curious. Alabama is constantly dealing with federal orders from federal courts and with federal precedent and Supreme Court precedents. Presumably some of those have been ones that you've disagreed with at various times. I'm curious why you are resisting this one in particular.
Well, this one in particular violates the Federal Rules of Procedure, Federal Rule 65 of the federal courts. I'm not opposing the federal courts. I'm saying that they've got to stick within the bounds of their own federal rules. And a probate court of Alabama is not bound to follow a decision of a federal district judge when that federal court has not been in the case before that federal judge. There's simply no authority for that, and even the federal judge, Callie Grenade, recognized that in a recent order regarding a contempt citation of a Mobile probate court judge.
Well, sir, in light of the answer you just gave, could you explain what the supremacy clause of the Constitution means to you then?
Yes, sir, I can. This Constitution and the laws of the United States made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or the laws of any state to the contrary notwithstanding. What that means is that between the two systems you have the state system and the federal system. And the state system is different because it has a constitution above it between that and the United States Constitution. All state judges...
If I could, sir, I'm sorry. I understand that in this case, as the minority opinion in the Supreme Court suggested, or the order that came out, Justice Scalia and Justice Thomas, I understand you think they deviated from what the norm would be. Normally there'd be a stay on what the district court ruled, but that's really a matter more of politics than of law. There's a federal court that has ruled about what the law should be in your state, and you seem to say it's okay to disregard that.
It is not only okay, there is no rule that you must regard it. The federal courts and the state courts have equal authority to interpret the Constitution under our rules today in the United States. For example, I'll quote to you from Lockhart versus Fretwell in 1993, and I quote Justice Thomas. In our federal system, a state trial court's interpretation of federal law is no less authoritative than that of the Federal Court of Appeals in which circuit the trial court is located. Then Justice William Rehnquist in 1974. Although the state court would not be compelled to follow the federal court holding, the opinion might of course be viewed as highly persuasive. This is an opinion of the United States Supreme Court in a California case in 2013. The views of the federal courts of appeal do not bind the California Supreme Court when it decides a federal constitutional question.
Let me just ask you
one question. Simply by law.
Let me just ask you one question of that, following up on that, Mr. Justice. If the Supreme Court, as you know, is hearing a gay marriage case this spring, if the U.S. Supreme Court rules that gay marriage is constitutional and therefore the law of the land sometime this spring, maybe early this summer, what will that do to your posture with respect to the supremacy clause, and what will you do there down in Alabama if that's the case?
The Supreme Court authority is the only authority, arbiter of a difference of opinion between federal and state courts, and it would bind state courts. But I submit to you, nothing in the Constitution of the United States admits the power or authority of the Supreme Court or any federal court to reinvent the definition of marriage. So that definition belongs to the people.
I'm just a little unclear.
Yes?
So you're saying if the U.S. Supreme Court rules in favor, says that gay marriage is constitutional, you will then allow gay marriages in Alabama or not?
I do not allow gay marriage anywhere. I will not change my opinion on the definition of marriage. Yeah, I said their opinion would bind the courts, state courts of Alabama.
If that happened and a federal court found you in contempt and sent you to jail, would you go?
For doing what? Thinking about something? I think I'd go. Would you?
You'd go to jail in defiance of the Supreme Court decision.
They can't rule your conscience. That's clear in law. That's what the First Amendment is all about.
Mr. Justice, there's great interest in you now.
I said the state courts would be bound.
Yep. Would be bound, right. Got it.
There's great interest now in you as a person, as there has been in the past when you've been involved in controversy. So I just want to ask you some questions about your own personal views. If someone you knew said to you that they were gay and invited you to their wedding, would you attend?
I've had many friends who are homosexual. I've treated people just like other people. This is not about how I treat people or how I go to a wedding or a marriage or anything. It's about the Constitution of Alabama, the Constitution of the United States, and specifically the Sanctity of Marriage Amendment Act or amendment to our Alabama Constitution.
So you wouldn't be reluctant personally to go to a same-sex wedding then, is that right?
I would not go to a same-sex wedding, no.
Why not?
I said I would treat people fairly.
Right.
Because that's not what I believe is the definition of marriage in our country. And what I believe is not what I'm basing my opinions on. What I'm basing my opinions on is the Constitution of Alabama. That's simple.
You've got people in your state now, a very chaotic situation. Some people are performing in the counties, are performing same-sex weddings, some are not. How do you deal with the fact that there are people in your state who love each other and like to get married, and a federal judge has said they should be allowed to, but they're not? How do you feel about that situation personally?
People can love each other and live with each other, but to get married in the state of Alabama, you have to go by the Constitution of Alabama that has been passed and that forbids same-sex marriage.
Mr. Chief Justice, back in 1967, the Supreme Court ruled on the case of Loving versus Virginia and said that interracial marriages were constitutional. It took many years, until 2002, I believe, for Alabama to take its anti-miscegenation laws off the books. Do you think those books, in that period of time after the Supreme Court ruled, and those laws remained on the books, that the state should have continued to enforce those laws?
No, those laws were immediately overturned by the Supreme Court of the United States, and we recognized that after 1967. But we also recognized in 1967 what the Supreme Court said about marriage. They said it was the right of every free man and woman to enter into the institution of marriage as a right of pursuit of happiness. That pursuit of happiness referred back to the Declaration of Independence, which stated that we hold these truths to be self-evident that all men are created equal and endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. The United States Supreme Court attached that to a right given by God, and it's an unalienable right, and what God gives, no man can take away. And I submit the United States Supreme Court, or no federal court, can take that definition away from the people.
Justice Moore, I'd like to sneak in one last question, ask you for just a short answer. It's a pretty simple question, but big philosophically. Would you prefer a system of government where God's law trumps state and federal law, or the system where federal and state law trump God's law?
Well, if you look at the organic law of the country, would you say the Declaration of Independence is law? Question. Answer. Would you say the Declaration of Independence is law?
No, it's not.
I don't hear an answer.
Well,
it's not. Well, you go to the United States Code today, and you find it listed as organic law, because all law must have a beginning. All rights must have an origin, and that determines where our rights come from and who gives them, and what government's role is to secure those rights for us.
Justice, thank you.